sometimes folks want to say, oh, I leave to John Doe $1. You don't necessarily have to do that. If you want to make it clear, we can do that certainly. The only person you cannot disinherit, though, and this is where it operates in reverse, of course, is your spouse. They are always entitled to 50%. Now, this gets a little complicated, and I've got a case right now that's pending where mom and dad were separated for 8 years. Never got divorced, but separated. Children are from a previous marriage. Stepmother and children do not get along for obvious reasons. You know, the stepmom left and they had been separated for more than 8 years, or 8 years or more. And so now, all of a sudden, there's a pretty significant court case going on over some fairly small pieces of property here in Frankfurt. As you can see, heirs property can really start affecting a lot of different folks. The other item that you really need to make sure you address, if you have minor children under 18, or you know somebody in your family who has children under 18, you absolutely need a will. If you pass away and you don't have a will, the great state of Kentucky will decide how to take care of your children. And you do not want that. I can assure you, you do not want that. So, when you start thinking about succession planning, when you start thinking about a will, start thinking about minor children, and really what you need to start thinking about is who's going to be the guardian. So now we're getting into how to address a lot of the heirs property issues by an ounce of prevention, wills and succession planning. Think about a guardian. That's the person who's going to be taking care of your minor children. You need to talk about it because a lot of times you think your spouse knows what they want and they don't. Or they've just never thought about it. You know, lots of folks come in almost every day. We'll sit there and go through all of our questions that we have to answer. Oh, all right. Now we got power. Let's see. Buzz? Yep, all right. So you want to make sure you name a particular guardian. That's the person who's going to take care of your children. A lot of folks are very, very much worried about what to do with the probate process itself. Lots of folks don't want to necessarily get a will because they're worried about how to take care of everything in court. It's not as bad as you might think. Usually we make sure that every paperwork is filed. That's something that we obviously can help with. And once we get a court case going, we get the will recorded typically, or we go through the steps if there's not a will, and we make sure that everything's taken care of. In Kentucky, it's a pretty simple process. We start by filing a small petition. That names the person who's passed away, names the heirs, names the property or assets. And then once we get that filed, we make sure that we go through the process. Kentucky takes approximately 6 months on a full probate. It has to remain open at least 6 months, and that's the period that the courts allow creditors to come in and make claims against the estate. Some of the issues that pop up, of course, assets can be very complex sometimes. It's hard to locate and get everything put together. Also, this is where you run into a lot of problems with finding heirs, potential heirs. You also have to be very careful here if the will is not written very well. What does that mean? If you say something like, I just leave everything to my heirs, but you don't take care of your property. They are the ones with the legal authority to take care of and sign for property, sign deeds, sign titles, whatever needs to happen. The executor is the person that can do that. Typically, it's going to be a spouse if you are married. If you do not, or a spouse predeceasely, that is on usually children, but again, it doesn't happen. If you select somebody, probably a good idea to talk to them beforehand. Just so they're not called or a little surprised. I always suggest contingencies. Let's go ahead and get at least one backup, two backups, or three backups is better. And that also applies to other individuals that you need named in the will. Other individuals that you might think about, trustees. Trustee is typically appointed in your will to take care of a minor child. At least for the money side of it. This is also a good area if you have two sides of the family in terms of mom and dad's side. Each side of the family, you have minor children. You can name one side of the family as guardian. That actually takes care of the child physically. And then you can name one side of the family as a trustee. That's just going to take care of it. So that's a good way to try to balance that out some. Of course, guardian we talked about, and then you need to select your heirs. If you don't have family or children, it's not a problem. You can select a charity, you can select a church, you can select a university. K-State would love to have me in their succession planning. I can assure you of that. And so it's wise, again, to have one or two contingencies down the line for whatever reason. And that's what a lot of folks name in their will. As we talked about, I hereby leave my property to my children, probably not specific enough to avoid heirs property. Property can connote different types of property, real property, personal property. So if you start out, I hereby leave my property to my heirs, already you've got potential complications. To my children, again, goes back to his, hers, theirs. My children could mean potentially my child that I've had with wife number one, that may be estranged, whatever the case may be, and my children with whomever. This comes up pretty frequently. I had a case a couple of years ago where we actually had to do a DNA kit on an individual who kept claiming she was an heir. And she was actually an heir. So she went and got the DNA test done. It showed 99.9999% that this individual who passed away was her father. And so all of a sudden we had to reconfigure all of the percentages to add her in to that estate. And then, of course, the term leave connotes a lot of different things as well. It's an acreage. I want to give 5 acres here to sibling A. I've got 5 acres here to sibling B. Or is it proportional? Or if the court can't figure it out, and there's a battle or dispute over that acreage or that property, but the court's just going to order it sold. We know exactly how much money there is at that point in time. Very easy to calculate from there. So if you want something different or something that needs to be addressed, this is the document to do that with. And this is the document that is be as specific as possible to avoid complications and to avoid heirs property. Especially with family farms, I deal with fairly frequently. Often there is a large tract, a 100-acre farm. A portion of it is the best farmland, and a portion of it has the house, and then a portion has a lot of timber. So if you need to divide that up accordingly, again, this is the document to do that. If it's got to be physically divided, probably a good idea to go ahead and do it before you pass. Otherwise, it can always be financially divided without any problem. But maybe those 3 tracts all equal about the same amount, or can equal the same amount of potential income-producing crops or what have you. So it's always good to start thinking about how do you want to divide this land or your family farm before you get to this part. Why is heirs property creating such a problem? In the legal world, we track property through what's called the title. As you probably know, that's typically the deed. Here in Kentucky, we have a county recorder. That's where deeds get recorded so that everybody in the public knows what it is or who owns it. And anything that disrupts that chain of title is what creates heirs property. And that's what happens with individuals who pass away but don't have a will. So the title attorney who has to go back and figure out who owns what, all of a sudden has to do a lot of different research here. Who's the record owner of the title? Usually at that point, mom and dad. But who are the actual ownership? It's usually the parent or the children at that point in time, typically. Part of the deed, if you look at your deed, has to have what's called a legal description. That's legally how we identify your piece of property. And a long time ago, it used to be, you start at John Brown's farm, down here at the oak tree, you go 500 yards to the rock fence, you go over that way to the creek. I mean, that is literally how a lot of deeds are written. Very, very confusing nowadays, because mostly those landmarks are gone. So now what you see on the legal description, it refers to a plat typically that's been recorded as well. Lot number 1 on plat A, page 23, what have you. So anything that doesn't have a good legal description also could cause a complication. One of the biggest problems that heirs property, aside from the chain of title, who's paying the taxes? Or are the taxes just mounting up? Of course, the government is going to get their taxes one way or the other. Taxes have to be paid. And nowadays, most counties are doing tax savings. Meaning, they sell off that tax lien to a third-party buyer. The county gets their money up front, but the heirs get a humongous bill on the backside because all of a sudden they're going to be charging more interest. They tack on a lot of different administrative fees. And then when you go to try to clean this property up for however many heirs there might be, all of a sudden you may have 10, 15, 20 years of taxes. And that can get also very complicated and very expensive very quickly. Most titles are run by a title attorney or a title company, and they want to see all these different things as cut and dry as they possibly can. And that's why they don't like trying to go down and track down all these different heirs, no matter how much their percentage is. It can be very, very difficult. Again, this is how heirs property just complicates itself moving forward. One thing that you can do prior to you passing away is possibly sign the deed over to your children before you pass. That is a way to handle and or avoid heirs property, because then you've got it out of your name, you've got it in somebody else's name, and that chain of title is usually intact at that point. So again, oh yes ma'am, go ahead. Typically no, because they're not legally able to sign contracts. Now, if you want to do that, then you need to have a guardian appointed. If their parents are not around or for whatever reason not available, then you need to have a guardian appointed. And that usually goes through a court proceeding, and you get a court order. So it's something that you do have to kind of go through some motions, but once you get it done, the guardian can then determine whatever needs to be done with it. A lot of wills, that's a very good question in terms of a lot of wills state that if we have minor children, then their portion is held in trust until such time they reach 18, 21, 25, whichever age you want to put in there. Most people kind of pick the magic age of 25. Gets them out of school. Hopefully they're a little older at that point, obviously, more responsible in their job, and so on. So that's a very good question. So back to the chart. I really like this chart. It just very much tells you a lot of, shows you visually, I think, the problem with heirs property. Rounding up all these folks can be very, very difficult. Let's just say, let's take away the grandchildren, great-grandchildren level, and we just deal with the 5 children. 5 children are still alive in this scenario. 4 of the children are married. So if you want to sign your property, mom and dad want to sign over to the children, not only do you have to have those 5 children signing, but now you also have 4 spouses who have to sign. The one there in the middle with the highlighted portion is the only one that didn't get married. So you can see where all of a sudden, again, this dower and courtesy interest can be a very large problem. Yes, sir.
So I'm going to ask a question that nobody wants to ask.
Okay.
In African American community, there's a predominance of deadbeat dads. We have all of these kids. They have property and assets. They have all these kids, some with their wives, some outside of marriage, and then they die. What option, and it's a common question, what can happen there? I heard you say something about the DNA. That's what I usually tell folks. They go out and look at some DNA, and then go and say, get prepared for a fight.
I think that's all accurate. I mean, you're going to have to figure out who the children are to the extent you can. Sometimes, like in the scenario that I had here a couple of years ago, the other siblings didn't even know this one sibling existed.
They never know.
Yeah. So that is a particularly difficult problem. Again, having a will or succession plan would certainly help that. But that's a complication that you run into.
And I'm just taking, I'm saying, again, the elephant in the room. The majority of blacks don't have this. They don't, you're a lawyer, you know what I'm talking about. We don't do the legal things to make that process easier. So where do they stand in those families?
Same issue. That's why heirs property really disproportionately affects rural and or minority communities. There's a lot of reasons there why individuals don't get wills, fear of lawyers, fear of the legal system. Those are all valid issues that lots of folks have. What we try to do is make it as easy as possible to get it. A simple will, again, is the $100 per person typically. And that just cures a lot of issues, just right off the bat. But, yeah, somebody would have to go and try to track up those kids down, and if they know about them, if you don't know about it, like this other scenario I had, I don't think that's can be held against you, but know somebody, that's the start, is trying to get that, because that gives you some tools, or gives an attorney tools to work with. There's a question here.
What if there are relatives that you can't locate and you run it in and they couldn't proceed from here?
And right now in Kentucky, that's not 100%, I don't want to say foolproof, it's not 100% necessarily how the court's going to let you do that. There might be some ways to address that through the court proceeding itself, but typically they're going to want personal service. And the reason why is the fractional shares. Title attorneys hate fractional shares. They want everything in a row because one of the highest, if not the highest rate of malpractice for attorneys is property. Because it's so easy. It's tax lien. It's so easy to, maybe somebody has two T's in their name and they spelled it with one. There's so many different scenarios that you can talk about. So, right now, no, that's not a valid way to proceed. So, well, all your senators, all your representatives.
See, our problem is, I see a person have 5 children, they have 14 children.
But yeah, all of a sudden you got,
But it's a mess.
you got triple in now. And each one, let's just say each one of those could have 2 children. So now you got 15 here and 30 here.
Oh, so sorry. I thought we were on break. Sorry.
Sorry. I had a stupid legal thing to tell you, but I'm sure it was very good. But let's go back. Yes, sir.
I've watched other families there. So is it prudent for, say, the establishment or post-dating or a post-name, LLC? So then that 20% ownership would be with LLC, and then it'd be, is that prudent or is that legit prudent? They can also, so to say, that the children, so the children name that they, let's just say the Johnsons, the grandkids, they were trying to clean it up. So this is Johnson estate, the LLC.
Are we supposed to be breaking at this point? Are we wrapped up? Or?
We are on break right now, but if we
I don't mind.
Is that the right idea?
That is a succession, possible succession plan. Forming an LLC or corporation, absolutely.